Oh, you got it. Thank you.
Could you get me a glass of water as well? Thank you. Things going up for you?
You know,
Nice Saturday. We'll figure out.
we'll figure out time. It's been busy. My son just graduated from high school.
My daughter graduated from college after 15 years.
Yeah.
Went to social
Okay.
work. We're proud of her.
Okay. Okay. Excellent. Excellent. That's. I'm Ginsburg. That's okay. You're fine.
Thank you. You want this back?
Thank you very much.
Thank you very much. Did I lose my?
Preemption in 30 minutes.
Say it again.
Preemption.
Thank you very much.
Right. Exactly. Okay. It's good that there hasn't been a whole lot.
Okay.
Already.
Discussion.
Yeah.
Great turnout, Sam. This is
Yeah,
your.
there's a lot of people. Yeah.
Yes.
All right, folks, this is the last part of the morning panel.
I've deprived them of an official break.
Can we take
Okay, we have two experts here who are going to speak to this captive audience about captive audiences and some other things. We have Roger King, has a career of more than 40 years, was a partner with Jones Day, and now serves as Senior Labor and Employment Counsel for the HR Policy Association. And in the other corner, we have Matt Ginsburg, General Counsel for the AFL-CIO, a graduate of NYU Law, where he was a Root Tilden Snow Scholar. Okay, folks.
If I could just say a word, if I may. Roger King runs an organization called the HR Policy Association. I've already praised American Compass. This is the brain center of the American capitalist class, the HR Policy Association. And Roger is a principal player there. Matt Ginsburg is a former student. You've all heard. He is a great success. I take pride in him. I just wanted to mention a course that I taught with Larry Gold, who was many, many years the general counsel of the AFL-CIO, a course in appellate advocacy, and Matt was a student in that course, and we saw his talent very early on. And so we're very proud of Matt. I just wanted to mention Larry Gold's name to all of you.
Shall we start? Well, Sam, thank you for having me. NYU Law School, great conference, and the turnout today speaks for itself. Preemption in 30 minutes or less, maybe. So I have a paper that it's a work in progress. You have it at your electronic materials, and I hope you'll find some time to look at it. I would welcome your comments. But let me just share with you a little of the background, and then I'm going to turn it to Matt for some questions and comments. The premise of my paper is that preemption in labor and employment law has been good for the country and should continue. It's under siege at this point in a number of different corners in state and local government entities. There are always winners and losers, depending on timing, of course. And there is a strong movement among some of my so-called progressive colleagues that Washington is totally broken. Perhaps they're right in that regard in part. And that the only solution to good government, particularly in labor and employment, are state and local governmental entities. And employee organizations, organized labor has had, I think, a relatively high degree of success in certainly blue states in the enactment of labor and employment legislation. HR Policy Association, as Sam alluded to, represents employers. We represent most of the Fortune 400 companies in the country in labor and employment, healthcare policy, and SEC matters. My gig is obviously labor and employment. I've been concerned about and following preemption for a substantial period of time in the employment area. The companies we represent, as I noted, are large entities. They have operations in jurisdictions throughout the country. one of their constant complaints is trying to follow the patchwork of employment laws, particularly in the leave area in this country. The administrative costs, the associated litigation expenses drain a great deal of resources. In my paper, I submit those resources could be better spent for employee wages, training, entrepreneurial opportunities. It's not a good use of our GMP. But nevertheless, that patchwork is out there, and it doesn't show any immediate signs of subsiding. More recently, however, the preemption discussion has evolved into what I would call traditional labor law issues. Particularly, we've noted that at least 12 states have enacted legislation that would prohibit employers from having mandatory meetings where any part of that meeting, whether it be at the behest of the employer or a question even from an employee, touched upon unionization issues, that is forbidden and considered to be political discussion, at least according to some of the statutes from the states. And just recently, we have seen a major development in the state of California. And if you haven't followed this, it's AB 288, Assembly Bill 288 in Sacramento. Essentially, what's going on in Sacramento is a movement by some, perhaps a majority of the General Assembly of California, to have a California NLRB. And I'm told by people that are close to the situation that there are, not surprisingly, votes to have that enacted. So I pose to you, if we have a California NLRB, do we then have a Alabama NLRB? Do we have a Mississippi NLRB? Do we have a New York, state of New York NLRB? Where does this lead us?
And that's for private sector employees, right?
Talking private sector,
Right.
yes. Is that good for the country? My paper traces the origin of federalism. It's clear to me, at least in looking at the Federalist Papers and the way this country came together on a governmental basis, that the founders had a strong preference for a strong central government, and that we not have 50 colonies, but we come together on not only basics of rights of all of the people that are governed, but also in the regulatory area. And I'm concerned, as noted in the paper, that federalism model is eroding quickly to the detriment of all. And I think unions are not well served by these developments. Adam, I'd be very interested in how you feel about that issue. Employees are not well served, and certainly employers are not well served either. Are we going to have competition between the states as to which state can be the most friendly toward employers or unions or employees? And will capital move accordingly? Will the regulatory body in a particular state become so close and friendly to one side or the other that influences commerce decisions? Perhaps. So I think, just to set the stage, Ray and Matt, that's where the paper goes. It comes out strongly for a few solutions in the employment area. I propose that we go to a safe harbor approach, which I think is saleable in Washington. And that safe harbor approach would essentially say, if you, an employer, meet basic federal standards, you are immune from state prosecution or state litigation in the employment area. It's a little more difficult on the federal labor law area. One solution would be simply to amend, I shouldn't say simply, to amend the NLRA to have a preemption type statute like we have for ERISA. My paper traces the success of ERISA preemption in this country, which I think has served all quite well. There are other potential solutions. This is a difficult political issue. that are really sort of strange political bedfellows here, Matt. We have the so-called progressive groups, primarily Democrats in the Congress, that have had success in their initiatives in the various states in the labor and employment area. And short term, they don't want to give that success up. Correspondingly, we have so-called conservative members, primarily Republicans in the Congress, that have a disdain for strong central government, they do not want more power in Washington. They're fearful of the increased administrative state. So those forces are hard to overcome. The word preemption is difficult, obviously, to get through that political maze, but a safe harbor approach, I think, will work and can work politically. So let me stop there. Matt?
Great. Thanks, Roger. Thank you first to Sam, to Professor X. Stryker for inviting me. I have fond memories at the end of that class. They dragged us down to the Second Circuit and made us do oral arguments before what was a very hot bench of the two of you. So it was a great experience. Yeah. And I'm glad we're having this conversation because I do think it's a worthwhile one. And I'm the commentator, so I'm going to ask you some questions, but I'll say a few things on your paper, Roger, and on the ideas. The first is that, and this has been sort of my general impression from the morning generally, is as someone particularly coming up from Washington, D.C., the ideas which I very much value and associate with this place from my own personal experience are important, and this is an important discussion. But it is very, very difficult, and I'm sure others in the room are feeling some of the same things, to talk about some of these, very forward-looking ideas in the reality in which we sit right now, which has been very much one of for the labor movement, of destruction recently. I mean, it's been a very hard last few months, and so having the sort of faith to reach across the aisle is something that's going to take some affirmative work. So I just want to name that thing here first. Having said that, we in the labor movement, and I know I've spent a significant part of my career arguing with people, strongly have supported federal preemption in labor law. So it's sort of a funny spot to be in sitting here today. But here, here's the question. What do we do in a world where we have no quorum on the National Labor Relations Board and where the president has expressed the opinion through an executive order that he ought to be able to say, or he can say, what the labor law is by fiat? Leaving aside whether we'd want federal preemption as a labor movement in that situation, and recognizing, it's been said several times, at some point the shoe's going to be on the other foot in terms of a Democratic president. If that follows through, a Democratic president at some point would have the same capabilities. But leaving aside the policy issue, is there really Garmin preemption today? I mean, this is a question to you and one that's been very much in the ether recently. With a board that has no quorum and with a president who says you are no longer an independent agency, do the purposes that there's no statute, there's no express preemption in the National Labor Relations Act, unlike ERISA, it's judge-made law. Would the court say that there's federal preemption today? And if the court would, what if the president in a year from now decides that he doesn't like the operation of the board at all and decides not to name additional members or to remove a member so there isn't a quorum? Is there some point at which there no longer is federal preemption because of what's happened to the board?
Possibly.
Yeah.
And that's one of the premise points that the California movement is starting from. And we had a recent paper from Professor at Harvard on that
Ben
very
Sachs.
premise, right?
Yeah, right, yeah.
Which is a very thoughtful paper. Well, let me back up. First of all, we need a central body in this country, in my opinion, to decide labor law issues. As Sam alluded to earlier today, the law of the streets, the law of the jungle is not acceptable. And if any of my colleagues on the management side disagree with me, I'll have that debate with them any day. The National Labor Relations Board, by and large, has served this country well in resolving disputes. This country's economy, this country's success, working class, employers, et cetera, have benefited by stability. That's what the Wagner Act was all about. Getting rid of the law of the streets and bringing some thoughtful regulatory body over labor disputes. So if any of my colleagues, whether they be in the administration or on the employer side, think that we should do away with the National Labor Relations Act and the National Labor Relations Board, they have a strong opponent in me, and I hope other thoughtful people. Having said that, this void, Matt, you're right, that is existing. We don't have a quorum on the National Labor Relations Board. We don't have nominees, which I think is unfortunate. And we have a serious erosion through executive orders, perhaps, as you mentioned, on the day-to-day decision-making, not only of the NLRB, but of other administrative agencies. I think that's a mistake, and I have voiced that to anyone in the White House that would listen. Frankly, that's not the way we should proceed. We need to preserve a central body to decide labor law in this country. That's why Sam and David and I, and we're going to talk about this later today, are proposing an Article I labor court. But I'll save that for this afternoon.
So, and I just say, in that context, I think it sort of illustrates why, again, leaving aside good or bad, but certainly explains why we're seeing in California, we also see in Massachusetts, we also, I think, see in New York, these proposals to have what I think of as essentially trigger laws, the sorts of laws that the anti-abortion movement, the anti-choice movement put in place in states, so that if in fact federal law falls apart, that the little Wagner Acts that already exist in these states but are basically moribund would spring back into effect. Now, to talk about the way I think about it, reading a lot of these laws, is that you have a range, not surprisingly. So Massachusetts has a law or a piece of legislation that's moving through their state house that is literally a trigger law. It says or pretty close to that anyway. We have a little Wagner Act on the books. We've had it on the books pre-Wagner Act. And if the NLRA is ruled unconstitutional, it shall spring into effect. And that, it seems to me, is both, it's hard to argue with, obviously doesn't have any present day effect, but is likely to move. In California, just to name what the law is, the piece of legislation is, my understanding is what it says is basically if in any given case the board doesn't act either because it's unable to or just doesn't quickly on a particular case, that case gets shuttled over to the California agency. That obviously is going to draw preemption challenges quite quickly. But I think the point is that everything power abhors a vacuum, and the labor movement's quite powerful in those blue states and is looking for mechanisms. I would like to think to prod people at the federal level to get back to doing the normal business of the board. And I think it's worth underlining that on January 20th that there were 2 vacancies on the board that could have been filled, and as you said, don't have nominees. And while we in the labor movement oftentimes quarrel with Republican boards, we also acknowledge that, 70, 80% of the cases are your routine 883s and 881s that are going to come out the same way. It's about applying well-established law to the fact findings done by the ALJs, and it makes a difference. So I don't know. I do feel like we have there is a common belief around the board, and I don't normally sit on panels and say great things about how well the NLRA is working, since we're usually want to talk about the PRO Act. But if we're talking about democracy and economic stability, it would seem like there'd be some common purpose towards having agencies that just function and get the things done so people can move on and plan for
So Matt, you and I ought to go up to the hill together.
Yeah, well,
We
you
can-
know.
yeah, we-
They're
Yeah.
very effective.
Well,
too.
and I'll say, I mean, again, just to put the finer point on the difference between idea and reality is that, we heard earlier about Senator Hawley's proposal to take a piece of the PRO Act. I mean, we have talked with him because we'll talk with anybody who wants to talk about the PRO Act. And it is literally the pieces of the PRO Act that Senator Hawley is trying to move they're not kind of like the PRO Act. They are literally cut and paste. We talked to him about that from the PRO Act and their provisions that are very important. It would be great if he can find, what does he need? 9 more Republican co-sponsors to move that. So we'll see. I mean, I'm not at all questioning his interest in it. I just whether or not there are others up there as well. Yeah.
Well, we can certainly talk about that. I do want to take a moment and commend American Compass, frankly. I think many of the thoughts that are coming from that organization could be thoughtful points, Sam and Matt, for us to discuss, frankly, both employers and employees. The remedies under the NLRA are not sufficient, period. Rogue employers and rogue unions should not get off scot-free or just delay justice. I mean, 10J, Sam's got, I think, an excellent proposal we're going to talk about later today, could be strengthened and should be strengthened. Transparency in the workplace, et cetera. I mean, there are many areas we could come together. As far as Senator Hawley's proposal, though, it's too one-sided, Matt. It's the PRO Act. I know we differ on the PRO. We had this discussion a year ago. I thought it was a message bill. I remember you said, Roger, it's not a message bill. It's a key piece of legislation. The problem with Hawley's bill, and I'm going to go after it Wednesday in testimony in the Congress, frankly. I'm going to go after it hard. It's not constitutional. Interest arbitration may work in the public sector, but you cannot impose economic terms and conditions on an employer through a private sector arbitration panel. You've got a takings clause problem. There's absolutely no way that's going to work. And his proposal also on the so-called captive audience speeches. Look, I don't know how you feel about the First Amendment, but that's something I think we all should agree upon. When you try to tell anybody that they can't speak about a certain issue, and indeed in the workplace where an employer can't talk to its employees about unionization issues, that's not going to survive. The Amazon case pending in the 11th Circuit, assuming the 11th Circuit gets an opportunity to decide the case, is going to strike that down on a content-based First Amendment basis. They did so in the Honey Fund case. And if you're not familiar with the Honey Fund case, that was a case involving the state of Florida's prohibition on an employer having a mandatory meeting speaking about the virtues of DE&I. That was struck down on content-based, rightly so. The same thing is going to happen with this so-called prohibition on mandatory meetings. I mean, I welcome Senator Hawley's interest in labor law reform, certainly, but that piece of legislation on first contracts is not workable, Matt. It's simply not. It's not practical. It's not constitutional.
I feel like I got us off on a sorry, I apologize. Can I bring us back to preemption for a second?
Yeah,
in your
absolutely.
paper?
Sorry.
So no, that's fine. But so I know you speak of a safe harbor in your paper, and it's really more about, minimum employment standard type laws. But it sparked in me the idea about, one of the parts of the act that's almost never used is 13C, the session where the board can cede theoretically its authority to do its business to state agencies that are essentially doing the same sort of thing. What if we tweak 13C to, right now it's too restrictive, and so the board basically never does it. But what if we tweaked it to let them cede authority, and then we'd have a little percolation in the states? So still have to apply federal law, the same basic standards. That would be part of the test, and I think currently is part of the test for ceding authority.
Wow.
But then if California wants to put a lot of money into processing things more quickly so that cases don't sit around, they could. And we might get a little bit of innovation in the states.
Well, if we cede authority to California, Do we cede authority to Alabama?
Yeah, no, we would, and that would be, but Alabama would have to ask for it, but if they wanted to fund their own agency, they could.
I don't know, it seems to me that puts us back in a predicament of not having a uniform national approach to labor law. I think there's just too much opportunity for mischief, frankly. And one of the problems with the board, Matt, at present, and you're right, 80% of the cases, maybe 90% of the cases are 81s, easily decided on a unanimous basis. But the policy cases aren't decided that way, and the flip-flopping that Sam alluded to is just out of control. But this body of law is bad, and I'm afraid if we go the route, not that you are recommending
No, no,
it,
I'm just, yeah,
but I'm afraid that we get into even more partisanship on our labor laws, frankly. So I have reservations about it, but it's an interesting concept. I suppose maybe we are there indirectly, though, right now, because federal law has been eroded or is not happening since we don't have a quorum, right?
Right, right. I mean, the other thing I'll just say that informs my thinking about this, and one is we've gone a whole morning, and I'm not casting aspersion, and nobody's whispered the word Loper. Actually, there was one discussion of pre-Chevron.
Local rights.
Yeah, Loper Bright. And you know, before at December 31st of last year, that was what was on everybody's mind, is how much that was going to change the law. And it still will. I just think it's not as front burner. I think we might be seeing, you know, your trademarks start to run out on oscillation, that we may see the courts start to nail down. Not that I'm necessarily in favor of it, but I just think that's the direction we're headed with Loper Bright, and might open up some possibilities for doing some more administration at the state level, since the law may end up being a little bit more nailed down by the courts post Loper Bright. Anyway, just a
No,
thought.
I
Just
think
a
that's
thought
an
to
excellent
kick
thought.
around.
Roger, can I
Yeah.
ask you a question about you? I haven't reviewed your paper in a while, but are you extending this to state employment laws? Federal preemption of state employment laws?
You have to identify yourself if you're gonna answer the question.
Sam S. Stryker, who hasn't received an honest reward for my work.
No,
Go
no,
ahead.
the answer is no.
Does not
No,
apply to-
No, my paper speaks to private sector, first of all,
Right?
primarily. But as far as state law is concerned.
employment law.
It would be leave legislation, it would be family,
Not the discrimination laws.
no. No. The patchwork problem that employers in this country are facing, and many in this room, whether you're on the plaintiff side or the defendant side, knows exactly what I'm talking about. I mean, in California, even local jurisdictions have conflicting laws on certain leave policies. I mean, that makes absolutely no sense, it seems to me. But when we get to federal labor law, we've got phenomenal jurisprudence in this country developed by the Supreme Court on garment preemption, machinist preemption. Why can't we agree that that ought to be our model going forward? And Matt, I think labor would be better served, whether we have a Democrat president or Republican president, it shouldn't make a difference. But we should have a neutral body to decide issues. It shouldn't make a difference who's sitting in the White House, how an 885 case comes out, or an 881 case comes out, or a labor policy case comes out.
All right, before lunch preempts this discussion, we have time for one more question. Anybody have a question? Yes?
Isn't that what the NLRB was intended to be?
Did you hear that?
What's,
Isn't that what the NLRB was intended to be in 1935?
Yes.
yes, yes, I think,
Oh, we had an agency that did that.
Well,
yeah, I mean, go back to 1933, 1934, look at the history in this country. We had labor unrest, we had the law of the streets. Labor stability, you're absolutely right, was one of the reasons we created, I believe, in this country, the National Labor Relations Board.
Yeah, and I mean, President Lanigan, yes, absolutely. But part of the reason I think we're having this discussion, and I know later this afternoon you all are going to talk about your labor court proposal, is because we see, you know, between the removal of Gwen Wilcox without cause, you know, the not filling of the board, the empty seats on the board, and the executive order saying the president can say what the law is, that we just have to be prepared for what comes next and be thinking about that. And so the labor court proposal is a good one. I will come help you with selling your idea to
Down the
Congress.
road.
Yeah,
Down the road.
But it's also why we're seeing this in California and New York and Massachusetts, is because workers have things to do, like bargain contracts and organized unions. Employers, obviously, I won't speak for them, have things to do as well. And so we've got to come up with answers. I mean,
I agree.
the current system has been torn up in the last few months, so we've got to figure something out.
I totally agree.
Ray?
All right, unfortunately, our featured speaker, the Honorable Andrea Lucas, will not be here at lunch, but our speakers are here. If anybody has any questions or wants some autographs from any of our speakers who have spoken today, feel free to speak with them. Thank you. Enjoy your lunch.